Hi, I'm Nikki, and welcome to Relitigated, the podcast where 5 legal idiots retry a real Supreme Court case. This episode focuses on Mapp versus the United States and is the last episode in our 3-part series about the Exclusionary Rule.
Hey there, sorry to interrupt real quick. This is Jared in the edit bay. We missed in the proofread. The name of the case is actually Mapp v. Ohio, not Mapp v. United States. Again, very sorry about that. Case is Mapp v. Ohio. Okay, back to the show.
Real quick before we begin. We try our best to get the facts and decisions in this case as correct as possible, but don't trust our legal knowledge. Enjoy the show.
Jurisprudence with a cat doing a thumbs up.
Oh, hell yeah.
Adam will probably design something real cool looking.
That sounds good.
Wait,
Yeah.
The cat needs to be in a powdered wig.
At least. At least. That's the minimum requirement.
You're just doing my work for me here. This is the creative process I inevitably would have gone through on my own accord, but you're just accelerating me. And that's what this is all about, is accelerationism. Am I right, guys?
That's
Yes.
true.
I
That's
don't
very
actually know
true.
what that word means.
Oh, yeah.
I thought it was about jurisprudence, but that's okay.
That word's out.
And speaking of jurisprudence, welcome to the Relitigated podcast. I am your host, Nikki, and I'm joined by my co-host, Jarrett.
What's up?
We also have with us 3 justices, except they're not justices or lawyers or legally informed at all.
That's absolutely
First,
true.
we have Associate Justice Adam.
Hello, folks. I'm here again for some reason.
It's the powdered wig. You can't get enough of it.
You can't take it off.
High on powdered wig fumes.
Is it glued to your head?
It's the Hotel California of headwear.
It appears to have a mind of its own.
This is why there's a Surgeon General's warning on the inside of powdered wigs now.
Every powder
yeah.
wig, yeah. So, and the powder refill cartridges that you can get at 7-Eleven.
And they're known to the state of California specifically to have cancer-causing chemicals.
Yeah, because it's just straight asbestos.
Nice.
And then we have Associate Justice Chris.
What's going on?
What?
Why was
What?
that meow so good?
Shocking training acumen over there with Kitty.
I know.
I've been spending my whole life for that.
More cats, less law.
Yep.
Yeah, it worked. It paid off, I think.
Yeah, exactly. And of course, we have our Chief Justice, Sarah.
Greetings to all. I will not be meowing this episode.
It's really unclear why you get to be Chief Justice every time.
Is it?
Yeah, actually, no, it's not.
Yeah.
She
It's
went
okay.
through the extensive nomination and vetting process and got confirmed.
Of course.
Yeah.
She was the only one smart enough to not put a powdered wig on.
Yeah. The powdered wig is within, you know?
Yeah, you were strong enough to just internalize that and not need a powdered wig. That's very brave.
It just eventually gets absorbed.
It's okay.
Reverse Thor's hammer.
It is full of chocolate.
Yeah. Here to be an aspiration for all.
Please
An
continue to
inspiration?
lead us.
Whatever. I'm the most jurisprudent. Let's just say that.
That's true.
So how this works is none of us are lawyers, right?
Nope.
100%.
Oh,
Yeah.
God, no.
Yeah, exactly.
Every week I desire to be a lawyer less and less.
I get it. Yeah. Jarrett and I have picked a real Supreme Court case, and our justices do not know what case we have selected. Not that it matters, because since they're not lawyers, even if we told them, they wouldn't necessarily know anyway.
Yeah, we're not nerds who have memorized the entire docket of the Supreme Court forever, like some of us.
You know.
I think Jarrett feels attacked.
I wasn't talking about anyone in particular, just a hypothetical someone.
Just hypothetically, if there was someone out there who in their spare time
Might be interested in the Supreme
Researched.
Court to the extent that, yeah,
wrote a script and invited their friends to talk about it.
that'd be kind of weird. I don't know.
Speaking of, Jarrett's going to introduce the case to us and walk us through the facts and events so we can all get familiar with the details. The justices are free to ask factual questions during this time, and we will answer as best we can. Next, we'll move into oral arguments, where today I will represent the petitioner, the person complaining, and Jarrett will role play as the respondent, the government, who is being complained about. We each get 7 minutes to make our case, during which the justices can interrupt us and ask us questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if 2 or more justices agree in principle, they can disagree as to why. Once we've finished our hearing and Sarah's court makes a ruling, Jarrett and I will reveal what the Supreme Court actually decided and talk about how we feel about the actual results. All right. Sound good to everyone?
Sounds great.
It's different
Sounds
from cats.
amazing.
Affirmative.
Yeah, I actually didn't hear you say the word cat once in that opening monologue, and I'm just going to let it slide this one time.
There's still time.
I'll try to do better next time.
Yes, please do.
All right, Jarrett, please introduce our case for today.
All right, here we go. Our case for this episode is Mapp v. Ohio. We begin in Cleveland with DM,
Oh,
who
no.
lived
Oh,
with her
God.
adolescent daughter in the top floor of a 2-family house that she owns. One day, 3 Cleveland police officers arrive at DM's front door looking to search the place. They had information that a person wanted in connection with a recent bombing was hiding out there. There was
Oh.
also information that a, quote, large amount of gambling paraphernalia was hidden in the home, end quote.
What goes with bombing stuff, you know?
Sure, yeah. The police knocked on the door and demanded to be let in so that they could search the house, but DM stepped away, called her lawyer, and the lawyer advised her that she should only let the officers in if they have a search warrant.
Thank you.
Sensible.
When she asked the officers for a warrant, they had none, and she barred them entry to her home.
Smart.
Good.
One of the officers informed his superiors that they couldn't get into the house because they needed a search warrant. A few minutes later, several more police cars surrounded the house. The record's not actually fully clear as to who knew what, but from what we can see, at least 2 officers didn't try to get a warrant, but nonetheless were informed by other officers that a different officer had actually obtained a search warrant.
Oh, Jesus.
It gets confusing when there's a lot of people on the scene. You know how it is.
Yes, exactly, yeah.
He said, she said.
But they said about themselves, that kind
Collectively in some sort of like blue wall. Wait.
of thing. Right. Regardless, there was no record of any search warrant, womp womp. It was never produced, and none of the officers later, when they were questioned, knew anything about it.
I don't know, Jared. I'm going to stop you right there because it kind of seems like case is closed.
Everyone's guilty. Yep.
They didn't have a warrant. I don't want to hear the rest.
Literally every single person you've mentioned so far is guilty of something.
Porque no los dos. Everybody use fire.
Porque no los todos.
I was gonna say it's todos.
Todos.
It's all.
Well,
It's deserved.
3 hours after the officer's initial arrival, the police knocked on the door again. But since when DM did not immediately come to the door and was delayed in answering, the police forcibly broke open the door and entered the home.
Classic.
At about this point, DM's attorney actually arrived on scene, but the police would not let him see his client or enter the house. Inside the house, DM encountered the officers halfway down the stairs from her unit upstairs and demanded that they show her the search warrant. The police held up a piece of white paper that they stated was the warrant. DM demanded to see and read that paper, but they refused to allow her to do so. And in response, DM grabbed the paper from the officer who had held it up. This began a scuffle. DM was able to get the paper away from the officer, and she put it in her shirt or blouse or whatever.
Yeah, her bosom.
During the ensuing struggle, officers were able to recover the paper, but it did require one officer putting his hands into her bosom to remove the Subsequently, DM was handcuffed for being, quote, belligerent. There were allegations that she had some injury from the twisting of her hand, and she was taken upstairs to her bedroom. Inside the bedroom, officers searched a dresser, chest of drawers, a closet, some suitcases, a photo album, and DM's personal papers. They then searched the rest of the residence, including the child's bedroom, the living room, kitchen, and dinette. Continuing to the basement, they found a trunk and searched through that as well. And ultimately, the police found lottery paraphernalia, which would be any illegal lottery, and obscene literature, which was illegal under state law to possess.
Can we clarify what gambling paraphernalia is, or is that a thing?
My best guess is it was probably,
this is like
log
poker
books.
chips. Log books, okay.
Like log books of like this person bought this number, this person bought that number.
Like, are we talking like they upended the family Parcheesi board and they're like, we got them, boys, we got some dice?
I think, let's see, maybe betting slips?
Okay, all right.
Yeah. Receipts.
Okay.
Let the people bet.
And this is distinct from the obscene literature, to be clear.
Yes.
Found with, I believe.
Ooh.
Scandalous.
I think it's unclear if it was found in the trunk or not. That was the vibe I got.
There was
found in the trunk.
In one party they assert it was found in the trunk in the basement. Another party asserts it was found in the dresser, I think, in the bedroom.
With all of these cases, the most interesting thing to me so far is it's just like jazz. It's the notes they don't play. Like, they don't even bother to go into the salient details of like, tell me more about the obscene literature. No. Not for this court.
Yeah.
It's the sharp 11 in the Euclidean scale.
Well, there was some description, books, and a drawing, a pencil drawing.
Wow.
Undescribed, because that would be obscene to describe its contours. It's illegal contours.
Yes.
Anyway, sorry. I've really been drawn to the prurient details of this case. So please continue.
DM was charged with possession of lottery paraphernalia, but she was ultimately acquitted of that charge because they couldn't prove that it was hers. About almost a year later, not quite a year later, DM went on trial for possession of obscene materials.
Oh my God.
At
Incredible.
that trial, the prosecution did not produce the search warrant, and they did not explain whether or not it existed at all. DM's attorney objected to the introduction of evidence from the search and filed a motion to suppress it, but the court denied that motion. She was then convicted for the possession of the obscene material and sentenced to 1 to 7 years in prison. DM's lawyer appealed her case to the Ohio Supreme Court, arguing primarily that Ohio's obscenity law violated the right to privacy. He also noted that the police conduct in gathering the evidence was unconstitutional. The Ohio Supreme Court ruled that there was a, quote, reasonable argument, end quote, for reversing the conviction on the grounds that the way the evidence was obtained was problematic. However, the evidence had not been taken from DM's person by, quote, brutal or offensive physical force, end quote, so it remained admissible.
Which constitutional amendment talks about brutalism? What?
Ohio is like an alternate universe where everything bad seems to happen.
Yeah, guys, we're flipping the script. We're putting Ohio on trial here.
Additionally, the Supreme Court had held in Wolf v. Colorado that the 14th Amendment does not apply in the prosecution of a state crime in a state court. Unsatisfied with this ruling, DM's attorney appealed it to the U.S. Supreme Court. The court also invited a lawyer from the American Civil Liberties Union, which is the ACLU, to submit a brief, and this lawyer actually joined the oral arguments. And during the petitioner's arguments, it was actually the ACLU lawyer who asked the court to consider whether state courts could use illegally obtained evidence at trial. Which brings us to today's question. Were the confiscated materials protected from seizure by the Fourth Amendment?
I'm still hung up on the dirty drawings.
You sound so plaintive.
It feels like we're being tested in this opening season to just see how far our liberal modern sensibilities can be stretched in the context of historical policing practices. Like, what ridiculous injustices will we encounter next week?
Pops reached into her bra
Hey,
to get the paper.
they're lucky that they didn't have. She's lucky that they didn't have their guns on them at the time.
Okay.
Quick,
Okay,
so
so
quick notes, some quick notes, real quick to
Yeah.
finish out some of the
Please.
facts here. Quick talk of precedent. Reminder that we've actually done some similar cases on this show already, and that they might apply, or you might be, expected to have those in the back of your mind. So the first one is Weeks v. United States, where our esteemed panel of justices decided unanimously that evidence obtained without a search warrant could not be used in federal court against a criminal
Facts.
defendant.
That's true.
And in the episode immediately after that one, our esteemed justices took on Wolf v. Colorado and ruled 2-1 that the Weeks decision, which applies to federal courts, does not apply to state courts. So state courts can decide for themselves if what evidence should be allowed and which evidence should not be allowed. And I just want to note that our own panel of justices rulings mirrors exactly the actual Supreme Court's rulings on the case. So the actual Supreme Court in Weeks v. United States was unanimously in favor of federal courts not allowing this evidence to be admissible, and was a, I believe, 6-3 decision in Wolf v. Colorado that state courts could decide for themselves what they wanted to do. I also want to remind you all of your Por qué no los dos, which you've already referenced yourselves, which states the Sarah Court decided that law officers who conduct illegal searches and seizures should be subject to punishment and the defendant absolved if possible.
Yeah, that's the thing we said once. I do believe we've been led into a trap, friends.
We must tread very lightly. But also, they didn't have a search warrant.
Indeed.
I still want to know why the state of Ohio has any interest in dirty drawings held in people's footlockers.
A pencil drawing.
The gambling, the gambling
they
stuff, whatever.
Erase it. You could just throw it away.
Right? Yeah.
What are we? Why is it's okay? So this must have happened in I don't even know.
1997.
Like the 1400s. Like, this is crazy.
1400s. The U.S. Supreme Court, of course. Yeah, well, it's also, there's no federal involvement, right? So that's part of it.
I guess the question at hand here is, Ohio allowed to be as garbage as they want? I guess.
Well, was Colorado?
There's nothing in the rules that says Ohio can't be garbage if they want to be.
That's true.
Yeah. Okay. Well, I'm ready to hear some arguments. And they better be spicy.
I guess one, before we get into arguments, the fact that the Supreme Court says that the way the evidence was gathered, it provides reasonable for reversing conviction, and then they were just like, nah.
That was just to be clear, that was the Ohio State Supreme Court.
Yes.
Yeah, actually, I do want to go back up for a second to the whole brutal force thing. Like, since when is that a qualifier that matters?
Also, didn't you say that she had injuries to her wrist? Like, she was injured.
Right. If they had just violated her rights more gently, this wouldn't be a big deal.
They would have violated her rights with words.
If they had whispered softly, like,
altercation.
"Ma'am, we're going to grope you to obtain this illegally seized evidence," and she's like, "Okay." That wouldn't be a big deal. But no, they had to be forceful. But it didn't amount to brutality, and therefore they're off the hook. This is like Calvin Ball, guys.
So the brutal and offensive physical force, it appears to come from other precedent, some other cases where they're talking about the methods, and talking about offending a sense of justice and, brutal or offensive physical force against the person of the defendant.
I'm absolutely reeling in how utterly subjective the most critical, foundational bedrock precedent of our legal system is. It's just like however a bunch of guys were feeling at any given moment. I guess that's the whole lesson we're supposed to be learning here.
Tune in next time.
Quick question. What happened to the bombing suspect?
We lost that plot.
Yeah, we just like dropped that.
Where did that go?
in
How did
passing.
we go from a bombing suspect to a pencil drawing of a peen? You know what I mean?
So, from what I can recall, I think they did find the guy they were looking for, but he wasn't in her unit.
So they just were like, while we're here, we might as well get this lady on something. That's the vibe that I'm getting with this whole thing.
He was on the property, just not in her unit.
Is that a euphemism? In her unit?
No, like remember they have the two, like the
in her
house
domicile. Okay.
So like the where she was living, they didn't find him here. They found him in the downstairs apartment, I think.
Slippery.
Yeah, she owned the place. It was a 2-family home, so she rented out, half of the house.
We have no idea what the original tip was that sent the cops here. Not that it matters.
Right, like who snitched, Again.
This is a very snitches get stitches paddle of justices.
Yeah, right. Of course.
We live in a contemporary age, my friend.
In a 2-1 decision, the justices have ruled that snitches get stitches.
Yeah, it was an anonymous tip called in, I think.
Always want to be anonymous, you cowards.
Yeah, see, again, this does not rise to my extremely precise and profoundly jurisprudent judicial standard of, if the evidence was so good, why didn't you get a warrant, you dummies? Like, could you not find any corrupt judge, any sleepy man in his night robe to come to the door and sign your stupid warrant in whatever godforsaken year this was? And you just had to go cowboy and just like search this lady's chest of drawers for dirty drawings. Like, how did we get here?
I think part of the issue is that some cops told other cops that there was a warrant.
The cop grapevine, of course. How foolish.
Cops should not be playing telephone.
They should not be allowed to speak to one another, actually. That's a new ruling of the court. Sometimes when I'm at work, guys, I like to sit and think, like when I'm looking around a meeting, like how much did this meeting cost? Like all these people are paid professionals with salaries. Like this is very expensive for everyone to be here for an hour. Do the cops ever sit and think about that? Like how much did this dirty drawing fishing expedition cost the state of Ohio? Did the state of Ohio ever demand a reckoning for the ROI on this goddamn expedition? I have so many questions.
This is the government. Government doesn't do that. ROI,
especially not in Ohio.
That's private industry nonsense.
Yeah, we're not returning anything. We
Today's
expect to be
episode
paid.
is sponsored by the Ohio Chamber of Commerce, Bureau of Tourism.
The River Authority. That's a thing, right? Maybe not. Is that a thing?
I feel like we've gotten way off track, guys.
Yes. I'm prepared to put 7 minutes on the clock for Nikki here to make her argument.
Mm-hmm. I'm ready to go.
All right, 3, 2, 1, go.
All right. Esteemed justices, we are here again.
Yes, we are.
And I'm going to start by once again reminding you that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This amendment also states that there need to be warrants based upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of law. And we are here again because of the insufficiency of state measures to date. This conviction is a violation of DM's constitutional rights under the Due Process Clause of the 14th Amendment because the case was based on the unlawful search and seizure from her home. Notwithstanding the absolutely silly law she was accused of violating, having obscene materials in her home not shared with anyone,
Retweet.
there was no warrant. This purported warrant has not been produced. There is no record of it. And even if there were any warrant, there wasn't. The lottery paraphernalia would have been the only thing listed on it. Despite the lack of the warrant, the police broke into her home, put their hands in her clothing, handcuffed her, hauled her around her own home, and crawled through every room in search of any scintilla that would suggest some criminal activity. Ohio law requires that a search warrant describe the particular things that police are searching for with language that is essentially identical to that of the U.S. Constitution. The law and the Ohio Constitution forbids any warrant except with probable cause, supported by oath or affirmation, and describing what it is they're looking for. The Constitution of Ohio, finally, states that an officer who engages in illegal search and seizure in a dwelling that uncovers no evidence is a trespasser and can have action taken against him or her. The search at DM's home was the very invasive conduct that the federal and state constitution sought to prevent, and yet here we are, again. The police's serendipitous discovery of materials was essentially their get-out-of-jail-free card, allowing them to escape any deterrence for their illegal behavior. I'll remind you again, they were looking for a person, they were looking for gambling paraphernalia, and yet DM is being charged up on obscene materials, not listed on the non-existent warrant. If the court thought that the states would police their police in the Wolf decision, this case and others like it show that these alternative remedies of lawsuits and public oversight over the police are not working. At this point, the court has to be the one to act to protect citizens' rights and ensure due process. The government has to follow its own rules, otherwise, what's the point of documenting its responsibilities and obligations? Why even have a constitution? So really, evidence obtained illegally should not be allowed at trial, and allowing it at trial is a violation of the Constitution, the Fourth Amendment, the 14th Amendment. Really, the court needs to re-examine this constitutionality of searches and seizures in state courts if federal courts prohibit the admission of evidence obtained illegally. By not applying the exclusionary rule to state proceedings, the court has introduced a conflict between state and federal courts. So, what's to stop a federal agent from testifying in a state court about illegally obtained evidence? How is this not just an end run around the Constitution for the purpose of getting a conviction? Now, in consideration of the Wolf case, the court did take a look at what states were doing. And so prior to that decision, almost 2/3 of states were opposed to the exclusionary rule, as the court determined. However, after the Wolf decision, more than half the states have taken up or followed the rule, either by passing their own laws or through court decisions. For example, California adopted an exclusionary rule on a court decision specifically because the other remedies did not work in getting authorities to comply with the Constitution. So if the court is considering how states are coming to think about citizen rights and searches and seizures, the trend among the states is toward the exclusion of evidence, and this consensus suggests that this protection is fundamental and necessary for the protection of our rights. I thank the court very much. I'm willing to take questions.
Nikki, no questions again from me this time. Stellar job. And yeah, I agree. I'm gonna be an interesting one for Jarrett to try to convince me of otherwise. Once
I don't
again,
think you can do that, but Okay, wait a second. I really thought I understood how the supremacy clause worked, and I'm less and less sure every passing week. Can you explain again what you identified in the Ohio state constitution that would make this search and seizure illegal? I think you mentioned that. I just want to make sure I was clear.
So Ohio has its own laws and amendments that specifically, require warrants, and they have this warrant requirement that's identical to the Fourth Amendment. In addition, there's Ohio law that says that if police engage in an illegal search and seizure in a dwelling and they don't uncover any evidence, then the police are in the wrong and can be subject to action.
Yeah, it seems fairly cut and dry. Oh man, this is going to go just like last week, isn't it?
Well, I think the difference here is that the police, they broke into the home forcefully, versus they used the key in the other case.
That's true. That's
They drove
true.
themselves in.
Great point.
Yes.
Wow. All right.
Mhm.
Man, a few words, but they were good words. The best words.
Thank you, Nikki. I think we are good with our questions.
It's time for the historical cat halftime, right? Right, where the cats do a little Super Bowl sort of thing, right? That's what we do.
Yeah, the Kitten Bowl.
The
Can we say
Kitten
that?
Bowl.
Is
How
that
did I forget
trademarked?
the brand?
The Supreme Court should adopt this practice.
They
It
should,
really should.
right?
It's
It would ease the
unfortunate
tension.
that they haven't thought of
These
this
seem
yet.
to be a better place.
Real lack of creative thinkers over there. Anyway,
2 observations. Number 1, I just love a justice telling my opposing counsel, "Great job."
nobody ever
Love
said that we
that.
were good at this. Nobody ever said that we were
I'm not,
impartial.
I'm not a lawyer. I'm not a judge. What do you want?
That's right, you're a
Secondly,
chief judge.
opposing counsel used the word scintilla, and that's a level of rhetoric I'm not prepared to rise to.
Actually, I made a
speak the
note to call
truth.
that out.
Yeah, good luck, buddy.
I was going to give her extra points for that, but I thought that would be impartial and thus not jurisprudent.
All right,
Yeah.
I've got my shovel, and I'm prepared to start digging whenever the timer starts.
Oh wait, let me grab my.
Prostrate yourself before the judges, fool. Give us your feeble argument before we throw you to the
Grovel
hounds.
for mercy.
All right, you can. You ready to go, Jarrett?
Yep.
Okay. All right, and 3, 2, 1.
Miss Chief Justice, and may it please the court. We really doing this again? This feels like deja vu. The last time this
yeah.
court met, by a 2-1 decision, you agreed that state courts have their own jurisdiction over the rules of evidence, and
You
this
really gonna
means
hold
they
that
can
against
decide
us?
for themselves whether evidence can or cannot be used at trial. If the wiseness of your decision demands reinforcement, let me remind you that the U.S. Supreme Court agreed with you as well. In Wolf v. Colorado, the Supreme Court also gave deference to state courts to make their own decisions. It is the respondent's opinion that this court, and also the Supreme Court, got it right the first time. After all, the state courts and the law enforcement members they oversee are much closer to the voting public than the federal government is. The voice of the voter is more personal in the states, and it should be respected. Now, make no mistake, the petitioner is not asking you to clarify or explain some unexplored facet of a larger question. At its core, this is the exact same case as Wolf v. Colorado. In both cases, we have defendants that have had property searched by police without a warrant. In both cases, the courts allowed evidence found in those searches to be used against the defendants per the statutes governing that state's courts. In both cases, the defendants asked this court to overturn those convictions because of the illegal search. There is a legal principle called stare decisis, which I've probably mispronounced. That means when there is a precedent telling you the answer, respect that precedent and apply it. We have a very clear precedent in this case that comes from Wolf v. Colorado. While evidence obtained without a search warrant cannot be used against a defendant in federal court, the states are free to set the rules and do what they want in their own courts. Overturning this precedent would be judicial overreach. In the time since the court decided that evidence obtained dubiously should be excluded in federal court, some states have adopted a similar stance for their courts, and some have not. At one point, it was close to an even split between states that did and did not embrace this rule. This is the well-oiled functioning of a federalist system that has many layers from federal to state to local. I also want to note the idea that letting a guilty person go free to punish law enforcement remains nonsensical. My understanding is that at the time of this case, Ohio law considered police officers conducting a search without a warrant to be subject to arrest for trespassing, at least if they didn't find something illegal, as well as they were open to civil suits. So they can't just be searching everyone without repercussions, and they should only be searching if they believe they'll actually find something or they will get punished. That is what this court said. You have to have some remedy if they screw up. There is a remedy if they screw up. This is the correct remedy for their bad behavior. Provide a mechanism that punishes the perpetrator instead of unpunishing a perpetrator of a wholly separate crime. I trust the justices will do the right thing and swiftly their own good past decisions here in this case and allow us all to move on to more pressing matters that we haven't already talked about. New horses not yet dead that we are not going to beat to death. Thank you. I yield to questions with my remaining time.
Man, I gotta say, like, the whole strategy of you guys were right the first time, very compelling, very strong. However, I do feel like you are slow walking us into defending slavery or some abhorrent shit.
Oh yeah, you're the villain.
You are absolutely
Four
the heel.
words.
You are absolutely the heel
Four
in this
words.
relationship.
Yeah, porque no los dos, right? We punish the cops for trespassing and hurting this woman, not having a warrant, doing all the bad things. And we drop DM's charges.
Wait.
Why do we have a constitution if it's not going to protect the people? Anyways.
The Constitution has, I believe it's Marbury versus Madison, gives the courts the ability to weigh in on the constitutionality and then to interpret the Constitution. And Ms. Chief Justice, your court has interpreted the Constitution as well as the Supreme Court. And
I don't like that you're calling it my court because I dissented
both
on Wolf v. Colorado.
That's management for you.
That the 10th Amendment that devolves power back to the states gives the states the authority to, to manage the process the way that they choose to do so.
I don't want to be in this court anymore.
I'll gladly be Supreme Court Justice if you just abdicate. This has now turned into an internal power struggle. Please stop the clock. Okay, wait a second. Focus. I think he might be right, and I hate saying that, but guys, somebody say something to tell me that he's not right. I'm very easily swayed.
So so two things, right? Two things. The first is that the police actually broke into the house this time.
It's true.
They waited, they broke in, they forcibly, they led not a witness, but like they led the defendant on, with the fake warrant, potentially.
That's true.
And kind of, mocked her almost. And that's kind of offensive.
I submit that that's not ultimately relevant. It was still an illegal search, which I'm not questioning.
Yes. Yeah.
What I'm saying is that in Ohio State Court, that doesn't matter.
Right.
It still produced some dirty drawings, and therefore...
But, so the actual law that we should look at the laws the Ohio Supreme Court has put into place and said, are they no good? Right. And like the law that they have, that actually the conviction of this person, right? The law that they are convicted, the crime that they're convicted of, right? Is that no good? Right. Is that constitutional or not?
As a representative currently of the state of Ohio, my belief is that the state of Ohio is governing its own affairs just fine without the input of the federal government. Thank you very much.
You
You're
would say that.
defending Ohio. Just remember that.
I'm defending who I'm not paid to defend.
Listen, he doesn't know anything except Ohio. We just have to let him be. He's a simple boy.
Okay.
Okay.
Those are
So
the two things that I had.
I think that is compelling that they had to break like a whole bunch of laws and just be jerks generally. I mean, let's just be objective about it. Just to get the evidence that what was the evidence again? It was some gambling slips or something, maybe some poker
That were
chips
proved not to be hers.
and a dirty drawing or two. First of all,
Pencil drawing.
I'm extremely invested in the idea that she drew these drawings herself, so I'm just deciding that that's true and canon. And every time I think about them, they become more and more disturbing. But yeah, I think that what they seized, like relative to how much egregious law breaking had to go on to seize it, that does feel that feels worth considering.
Yeah.
Couldn't agree more.
Like if she had killed 17 people on her way home and they were like, we saw her trailing blood as she was eating the human heart.
That's probable cause.
That's
definitely.
probable cause. I guess that's probable cause. So we're so far beyond that conversation of probable cause at this point. It's like, how badly did they break the law to get into her house?
They were just in her house. Anyway.
You close your eyes and just you open them and all of a sudden the cops are in your house and who can account for it? It's just very powerful.
My time has long since expired, so thank you kindly.
I'm over here pontificating on the magical powers of the police in Ohio specifically. If anyone has any leads on this, please email the show. Let us know. Have you seen the cops undergoing any sort of transmogrification or teleportation? We want to know about it.
Good jurisprudence.
Thank you. I agree.
I think we're well into deliberation at this point. I think we were into deliberation as soon as Sarah said, "Great job."
I don't want to waste time. I know I go with my gut and I know what I believe. And that is why I am not actually in practice a lawyer or a judge.
Yeah,
that's true.
I'll take it a step further. I've never actually read a full Supreme Court decision from start to finish. I'm familiar with loosely how they work. Do they ever get a chance to riff in those things? They're very opinionated, right?
Yeah.
This part at the end.
Yeah, this
after
part
the decision's been
where
made.
we deliberate.
Yeah. They read a lot like papers I used to write for school where I knew what I wanted to say before I read the book I was supposed to be writing about.
Mm-hmm.
And then I was like, oh, I should probably go find some things to corroborate my opinion.
Natural born lawyer. That feels like you got the instinct.
Yeah, you sure you're not a lawyer?
And
He's very
anyone
smart.
who listens to this is
Very sure.
definitely not a lawyer.
But
Yeah.
you could if you wanted to be. That's why we believe in you. You're a very smart young man. Okay, we got to deliberate.
Thanks,
We got an important task in front of us. We have to decide just how naughty can the police be before it is in fact them committing the crime.
I'm going to start by saying it's going to be hard to move me on this one because
Clearly.
in Wolf v. Colorado, I dissented.
We made a mistake.
Right. I was thinking, I didn't want to come out and say, hey, Adam and Chris, you guys made a mistake. Because,
That would
respect
be
your opinions as
uncool.
members of my court. But I just think fundamentally, if the Constitution under the Fourth Amendment protects people against being searched without a warrant and all that good stuff, then why can the states just decide in their little courts that they just don't want to use
little pitiful, meaningless, literally unconsequential courts.
They're tiny, minuscule courts.
I was not imitating anyone. Okay, you know what? Actually, it's the fabricated search warrant that gets me here. As I reflect on the material evidence,
that's so low.
It's the fact that
it's so low. What are we doing? Be professional.
I'm also
At that point, they lose whatever like cop license, any cop latitude that they had. They lose any sort of benefit of the doubt.
It's embarrassing.
And they're
Are they
just
not
goons.
embarrassed? Like, that's silly. Ohio is silly.
I'm willing
So,
to condemn the entire state for this. Yeah.
I think the Ohio State Supreme Court, they kind of opened the door to say that the way that the evidence was gathered provides the reasonable argument for reversing conviction.
Absolutely.
But like my thing is that they have made decisions that kind of go against their own ideas, right? They're basically saying, yeah, we have these laws, the cops didn't follow them, but you know what, hey, meh. And then now we're kind of sitting here saying, did you actually enforce your own laws,
I
right?
feel like that cat is also very outraged.
That cat's an anarchist.
He's pissed.
Less law,
So
more
bad.
cats. That's what we've been
Less
saying.
law, more cats. He's screaming.
He's screaming for justice.
I am a prisoner in my own office.
He's saying, let this case go. The Ohio Supreme Court should let the cops go to jail. Yeah, I know, buddy.
No, that
I
cat
think-
is a state rights absolutist.
That cat's a fascist.
My cat's a fascist.
That cat believes in the 3/5 compromise.
Jesus.
Okay,
Too far. That one's too far.
All right, hey, order in the court. I think that was a good time to say that.
I'm calling your cat a racist for the record. I just want to make that super clear.
Oops. Sorry, Chris, you were so rudely interrupted by a
By a
feline.
kitten. The kitten was had a lot of opinions. But I do think part of the appeal, right, was that the obscenity law is unconstitutional. And so I think it's in our right to evaluate that, right? Because the
Can
state
we?
court, because the Ohio Supreme Court or Ohio State Constitution has made a law that could potentially deprive a person from their life, liberty, whatever.
But wait, are we
property.
allowed to consider that
I don't know.
in the proceeding of this case, or do we have to go separately, decide that's unconstitutional, and someone else could revisit this case? I don't know. This is all
That's a good
fake. So.
question. We're not lawyers, so we don't really know.
Yeah,
how that
Jared, you
works,
probably
but-
know.
You guys can just
said
kind of.
this in a previous episode, but it's who's going to stop you?
Oh, yeah, that's true. I guess the only rules that are here are just the ones that we make up as we go, right?
I'll be honest with you. This would be going after the state while still keeping us, that what I can't think of the word that I want to say. I don't know. Like our previous ruling was that the state can do what they want within reason, right? Because the state, the state can't just be out there just doing shit.
Lot of
And
latitude
then,
within reason.
We come up and we're like, no, this actually doesn't look right.
Pennsylvania,
so I
you
think
can't
we
let
should go
dogs vote. That's not allowed.
Yeah, right. It's a shit like that. So, or stuff. Sorry.
No, we're allowed to curse. We're justices. Yeah. Who's going to stop us?
Yeah, you're right.
God, I
Everyone's
wish you
a
hadn't
No
said
rules.
that. I really wish you hadn't said that.
So anyway,
Okay.
Yeah. Okay. We
that's
got
kind
to
of where,
focus.
that's where I'm at. Is I think we should go after the state for being bad.
All right. So it
as
really
a-
does come back to what were these drawings? How obscene were they? Can I see them?
asking for a friend.
Do they exist in the case file? I'm going to look this up later.
So actually, I can kind of speak to that a little bit.
Oh, God.
I just want to know how obscene they were, because that
So-
really matters.
There were some pornographic books, and then one was a pencil drawing.
She did it. She made it.
By the
I'm saying the cop did
time
it.
the arguments were made in front of the actual Supreme Court, the book of obscene material had gone missing.
Just mysteriously into the evidence
my
room.
God.
And then when the authorities recovered it, they found only the cover.
Oh, my God.
Also, having actually listened to the oral arguments, when that information became made known to the court, the Supreme Court of the United States had jokes.
I mean,
It is somewhat worth listening to if anybody wants to go.
They can't even
to
take
OEA.
the Ohio law seriously.
it is very funny.
Yeah.
Oh my god.
Okay.
Oh God, I think we know enough, guys.
Yeah, I think we're all on the same page. Okay, so as a team here,
Ohio is illegal. That's
Ohio
the
is
court's ruling.
banned.
Just doing illegal shit.
And why do we care if somebody has a pencil drawing of something obscene? It's not hurting anybody. It's in their house.
I can't
It's
wait
part
for
of their
Jarrett to dig
private
up a
property.
Supreme Court case where you have to eat those words.
Yeah. Well, we'll see.
It exists. It might not be our Supreme Court, but it exists in some Supreme Court. Yeah, no,
That's true.
I got to agree. Like, let the lady draw her smut and the gambling's
Yeah.
whatever. Like, fine. Slap her on the wrist for the gambling. But you
yeah.
can't even return her evidence because it's been pilfered one gross page at a
Everybody
time.
is wrong in this.
Everyone goes to jail. Everyone goes to horny jail in
Porque
this
no
case.
los dos. So
Porque
bad.
no los todos. I think that's new precedent, guys. I think that's new.
Yeah, porque
Canon,
no los
yeah,
todos.
to los todos.
Yeah.
No, porque no los todos. Everybody's guilty. Everyone with this. You know what? We're just going to call a collective mulligan. Everyone did something wrong here. I'd like to think we all learned something. We all go free.
Mi dispiace a tutti.
I don't know what you said there, but I'm going to agree wholeheartedly.
I'm sorry, everyone.
But I just want to clarify, when you say everybody did something wrong,
Everybody.
DMs?
We're all
No,
sinners.
DM's fine.
Nah, DM's good. Yeah, she's cool.
Yeah, DM's good.
Because I just like to point out she was acquitted of the gambling stuff, I think.
Yeah,
Oh, good.
let her
Yeah,
go.
see? Right. Let her have her keno or whatever it is. Come on, you prudes. Let her draw her smut
Okay.
and have her keno. God, I really want to be friends with DM.
And then just for some clarification, so there was a lot of lack of clarity as to where they found the obscene materials, and part of it
Also important, actually.
was because it was DM's allegation that the materials actually belonged to a former male tenant. So there was a male tenant or boarder who lived there, and then he left. I think he got detained somewhere in another state or
For
something.
drawing smut.
He
Jeez.
basically, she was like, "Are you going to come back? Are you going to like pay your rent?" And he kind of ghosted. So she just kind of like packed up his stuff and put it away.
He sent her a
That was-
dirty drawing that said, "This is your rent."
Imagine going to jail for 1 to 7 years
Yeah.
because some dude left a sick drawing of a
So
naked
sick.
lady somewhere in your house. Like,
So sick.
huh?
Dude, yeah, like my college roommate could have sent me to jail for life under those
It's-
auspices.
Let's hope your college roommate doesn't hear this. Well,
That's true. There
don't
is a
know,
high
maybe.
probability that may happen.
Yeah.
I think this obscenity law, we need to look at that.
It's got to
Let's say,
go.
what the hell's going on, Ohio?
yeah.
This law, it's no good.
I could agree with that. I mean, at the end of the day, I still stand with my opinion on Wolf v. Colorado that this
We were wrong.
based on that, none of this evidence should have been allowed anyways because of the way that the police went about obtaining it. But for the sake of honoring the precedents of my own court, I think that the next best step of action here is to go after this silly little Ohio law because it is silly. And people are going to jail for it.
Yeah, right. If we can't prosecute literally everyone else involved in this, we should at least take a hammer to the obscenity
down
law because
Ohio,
it's kind of
Or
wacky.
whatever.
Wait,
Yeah.
what? Destroy Ohio? That was what I heard.
That too.
Take
Sorry,
it down,
Ohioans.
Anyway,
I've never actually been
Okay.
to. I've driven through Ohio, but like, Jared, you and I stayed there for one night. That was never an appreciable amount of time, though.
We did. We went to a TJ Fridays.
We watched the
Wow.
Simpsons movie in a
Yep.
cheap motel. That was our Ohio experience.
Yep.
That 90-degree turn in Cleveland was okay.
Since Cincinnati is the home of the U.S.'s largest Oktoberfest celebration.
Oh.
They
Just
also
Ohio
have a
things.
they also have a really good chili there.
They look forward to it all year.
I did have some, and it was okay. It was good.
Okay, so we'll change Ohio's laws, but we won't get rid of Ohio in
Okay,
its entirety. yet.
Ohio is legal
Ohio,
again.
Ohio, you're safe.
You skate
for
by
now.
on the chili, guys.
Yeah.
Yeah, but stop the
Okay.
obscenity law.
Yeah. All right, fellow members of my court. I think that we have, what's the word? Deliberated long enough about this. I feel like we're all on a similar wavelength here. Clerks, I would like to say that we are ready to proceed forward with our decision.
We're unanimousized, and
Yes.
I'd like to blow the ceremonial unanimization horn. We're unanimous.
Ah, we should get one of those. The horn of
We're gonna-
jurisprudence.
Gonna get a relay horn for next time. But we're unanimous, folks.
Can it be like a gong instead
Yeah,
of
it's
a
actually way
horn?
better. We'll do that next time.
Yeah.
Nice.
So, as clerk, allow me to try to summarize.
Oh, bless you.
Yeah, good
Bless
luck.
you. I have no idea what I said, so.
So you have it sounds like Sarah is the source of the majority opinion on this one, and everyone is joining her.
That sounds right.
And that the obscenity law is a violation. I'm going to put it out there that you're probably mean the First Amendment.
At least.
Yeah, I mean, what else would it?
Like most of
I'm
them.
sure it violates other things
Yeah.
too. Like free. I don't know. Is drawing porn like free speech? Probably.
So the opinion is the law under which DM was tried and convicted is unconstitutional. Therefore, her conviction is reversed and the law is struck.
We're barely recognizing the authority of Ohio to exist as is. So, like, yes, the obscenity law, kind of whack. Don't believe in it. Won't abide it.
Okay. Yeah, the way what I wrote down was by unanimous decision, the Ohio obscenity law is stupid and illegal. Ohio is
Good.
barely
Yeah.
legal.
Nailed it.
That's it. Good
You
job.
exist by the grace of this court.
Follow up. Does the court want to rule on the admissibility of the evidence, or does it want to just put that question aside?
I rule the cops dilatory, and everything they did dilatory.
Listen, guys. If hypothetically I were to rule on it, I would say that I don't think that the evidence should be allowed because there was no warrant and because they went about gaining it in a very silly way with the fake
The shenanigans
paper.
is very weighing heavily
Like
on this
they
court,
attempted
yes.
to deceive. Like it was just a very dishonorable operation overall. So that would be my opinion on it. But as a court, do we want to actually rule on it?
I think we want to establish a shenanigans canon here, where if law enforcement abrogates their duty, and like if the cops have to break the law to enforce the law, what good is the law?
Yeah.
What are the good guys anymore?
We should implement a 3-strike rule on the cops. I mean, make it 2 strikes. 2 strikes. 2 strikes. Screw it. We'll change the rules. So I think it should be a 2-strike rule where, in this case, the cops not only broke into the dwelling, but then led the witness on, or not the witness, the defendant, led her on, and then at this point went in and forcibly removed the paper back. So I feel like that is enough to say that the cops we're not. I think the evidence should.
Okay, that's eminently fair. You are allowed to break the law 3 times, and that's it, Buster.
Well, that's why I said 2 strikes. I was like, this is like there's you can point out a lot of things wrong with this, but like the
surely
breaking,
yes,
the breaking and entering is a big red flag. With no warrant and also no probable cause.
Right. Like if we allow this, then we are just abiding squads of thought cops to go about pre-criming all about the place. Just breaking and entering into any sort of shady dwelling to be like, is there any crime going on here? Do you draw on any dicks? What's going on in this living room? Oh, you smoking the marijuana? Shit, that's legal. You get away this time, kids. But if I catch you drawing dicks,
Not
like
allowed.
that, we don't want that future, do we? I don't.
No. I agree, Chris. I mean, I think just any reasonable person would look at the facts of this case and say, damn, DM did not deserve all of that.
She seems kind of cool to boot.
So I think reasonability? Reason, is that a word?
Oh,
I'm not a
God.
lawyer.
Words?
I think reason is, well, lawyers say reason a lot, right? Like reasonable doubt. I don't know, like what would a reasonable person think or do?
That sounds totally cromulent.
Yeah,
Very cromulent.
the cops were unreasonable in all of their methods. So
let me amend the summary and
Yeah,
make
good
sure
luck.
that so this is the summary of Sarah's opinion, and then Adam and Chris can decide whether they want to join it or have their own side opinions or whatever.
Indubitably.
Is that firstly, the Ohio law that DM was tried and convicted for is unconstitutional and should be struck, and therefore the conviction should be reversed and send it back to Ohio. And also,
Sentence in and of itself. Back to
and
Ohio.
also, in recognizing precedent that in the Wolf case, you are amending that precedent to say, okay, that precedent stands, provided the circumstances are at least a little reasonable.
Yeah.
And we've defined that quite concisely and with
Yeah.
no room for error by saying you get 3 oopsies and then you go to naughty jail.
And then also I liked Adam's use of shenanigans canon.
The shenanigans canon.
canon.
Right. You are allowed to
Yes.
commit 2 acts of shenanigans in your duty as law enforcement officers. The minute you commit a third shenanigan in the course of a single investigation, and God, there's a lot. There's a lot of
Yeah.
edge cases we've got to explore here. But you do 3 shenanigans, you're out, buddy. You are now hunted. You are part of the criminal element that we are sworn to
Hang on,
prosecute.
guys. Do we have to get into the weeds about what constitutes like a normal, reasonable shenanigan and like
Versus
a
an
major,
egregious shenanigan? Yeah.
horrible shenanigan? Like,
Yeah. Yes. So, follow-up question from clerk. Would the Sarah court like to establish a test? Your very own test
Or
that
do they
other
want to
courts
kick
would
it
need to use to determine whether or not it was reasonable or unreasonable.
I'm
or
feeling
kick it
spicy.
down to a
yeah.
lower court
Or kick it down to a lower court to
on a
develop
not
that.
Ohio.
on a procedural issue and let the states figure it out until it ends
We-
up back in front of you guys?
Wait, states plural, or are we trusting Ohio to decide this?
I don't trust Ohio.
I don't either. We have to make this canon right now. Okay. We're going to go ahead and say that a major shenanigan involves abridging your national U.S. constitutional rights. Doesn't matter if you're in Ohio. Doesn't matter if you're in anybody else's sovereign. Well, it doesn't matter if you're in someone else's sovereign territory. If you're in Canada, this would not important. If you get your constitutional rights abridged, that's a major shenanigan. Doesn't matter where you're on the U.S. If the cops break the same law that they are investigating you for, that's a major shenanigan. If they reach inside your undergarments in any capacity, that's a major shenanigan. That's pretty much all the
Shenanigan of
ones
the
that come to
highest
mind.
degree.
Like, those are the ones that are canonically established by this case. And I'm sure there are more, and we will find them and we will add them to our rich canon.
So this is the Sarah court's shenanigan test.
Yes.
Is did the police violate your constitutional right, even
Yes.
though precedent here says that doesn't matter? But so was your constitutional right violated? Did the officers reach into your clothing in any capacity?
Oh God.
And a third thing that I have already forgotten.
Oh, if the cops break the same law that they're investigating the suspect for.
There you go.
That
If
feels
the
really
police,
important. Yeah.
and so that's the test. If a case comes before a lower court, you want them to apply that test and make the decision and leave you alone.
Good luck, lower courts.
So if the cops conduct a major shenanigan, so like breaching the Constitution, then that evidence is not admitted?
No, you gotta commit 3 strikes, 3 major shenanigans, and then
So if all
Wow.
three parts of the test are true, then
any-
the evidence in
No.
any court,
Hold on,
state or
hold on.
federal,
Okay.
any 3 parts of this wholly unfinished test that is very much a work in progress. To be clear,
I
is
see.
the court
Okay.
allowed to do that? Maybe
So-
the court
Some
leave
of
this
it.
an open draft.
So if I'm on trial and I can prove that the police who gathered evidence against me screwed up in 2 other previous cases.
No.
They
In
failed this
your
test.
case,
No, it's
No,
within
no,
the
no,
same
no, in
procedure.
your own
yeah.
case.
Yeah. The clock
So how
starts the minute they
does
start
the 3
investigating.
strikes
it.
work?
So
How does the
let-
three
I
strikes
think
work?
that's if it's a minor shenanigan, maybe.
no. So okay.
It's
So
the sum of any.
it's exactly right.
That's-
They have to commit 3 shenanigans in the course of the single investigation against their target, and in that
It could be
case,
the same shenanigan.
Okay,
They-
so
they
they could violate your civil rights twice and
Exactly.
then grope you, and then that would be 3.
and be subject to rules hitherto undefined by us.
Is groping you separate from just violating your civil rights?
Yes,
That like
clearly.
that's a separate right? Okay.
There is no constitutional amendment that says they can't reach into your pants.
Thou shalt not
is that-
be groped.
Is it your
I
property?
do think that might be the 4th Amendment, but
Yeah, I think that's
who am I to say? I'm just a lowly clerk.
None of us have any idea what we're doing here. That's clear.
Okay, so
okay,
what
yeah,
I
this
really
is-
want to know now, Jared, is
this
if
is
we're gonna have
exhausting.
are you gonna have a spin-off episode with a new set of justices to be the lower court that actually has to rule on this test?
We've dug a deep hole for this.
We've already seen things that you have decided come back and have to factor into new things you must decide. So that's why Nikki and I are trying very hard to make sure that we get this all down very clearly, so that whether we bring
You can hang us
a
on
new
it later.
case
Yes.
or
Yeah.
some new justices come in or whatnot, we need to be able to fully inform them of the canon of our
Shit.
podcast universe. So we need to know the test.
Guys, we might
Also-
get fired.
Also, I think it's delightful to watch the 5 of us who have no idea what we're doing try to design a test.
Mm-hmm.
You know, I've
I
known you
didn't
a
even know
long
this would
time.
happen in
I'm not
law.
even good at my real job.
I've known you a long time, and I've stepped into every trap you have sprung for us so far. Bravo, my friend. Bravo. This whole law thing is really complicated. This is why you got to go to school for it for so long.
Mm.
I presume. I don't know. Having not gone to school for this.
I think it's linear.
I think this is as close as we're going to get to
Mhm.
resolution. But it sounds like Wolf still stands, just with caveats.
Boo, but yes.
Wolf
I would
stands.
love to strike down Wolf.
The thing with Wolf is that there was really, I mean, yes, the cops let themselves in with a key, right?
You're thinking of
They were-
Weeks.
Oh, I'm thinking of Weeks.
Wolf they went to the doctor's office and
And like
Oh, that's
took
right.
books.
took his
It was the HIPAA violation
yes.
everywhere.
That was subject to major shenanigans, but only 2, and that's how they got away with it.
That's true. That's true. There were only 2.
Yep, only 2 that this court got.
I think you did it. I think you
Wow.
I think you solved it.
Really threaded that needle, guys.
So the Ohio law is unconstitutional. DM should be released, and the Wolf decision is further clarified with the introduction of the Sarah Court's shenanigan test.
Yes. Yes. Major shenanigan test. We have to at some point differentiate minor from major, which will theoretically be an entire minor in law school.
But
Accurate.
Wow.
Gosh, please don't edit out you feverishly typing.
I'm taking some, like, I need to
That's
take
the sound of history.
up with what's
Yeah.
happening. Yeah, this is jurisprudence.
Yeah, the audience needs to know that the notes are diligently being taken.
Notes are important.
I mean, you can't hear it, but I am furiously drawing courtroom sketches. But because this is a podcast and I'm alone in a room, it's pretty uninspiring.
We can rent a court, right? Is the Supreme Court in the state on Airbnb? Can we rent it out? Is that not a thing?
Should we go camp out in the Capitol building?
Yeah, go camp out in the Capitol building. Yeah.
My only regret is that I can't be with every lawyer on earth who ever listens to this to watch and observe the all the stages of grief pass over their face.
Yeah.
In just a moment.
Yo, I'm just coming around to the fact that you used us as weapons in a literal war crime.
Yeah, condolences. So sorry to any law professionals who do take the time to listen to this.
I'm actually not sorry.
We're very sorry.
I'll do it again, and I will do it again.
An invitation to law professionals to come on the show and learn us a thing or two.
I can imagine just angry emails.
Joke's on you. I'm incapable.
We're going to get
learning.
hate mail for sure.
100%. Without a doubt.
Get in the comments. You hear that? Law subreddit? Get in the comments.
Fight.
Oh, man.
I think we owe everybody some actual history and results here.
Oh, I thought you were going to say
what
apologies.
actually happened?
I forgot about that.
Yeah.
I was like, oh, yeah.
I was fully ready to apologize to everyone in the state of Ohio, but yeah, continue.
Yeah, there was a lot of information, partly because we had access to more information. So it got pretty interesting. But anyway, so Mapp versus Ohio was argued March 29, 1961, and decided on June 19, 1961. And it was a 6-3 decision in favor of DM. So,
Woo!
Right side of history again.
Good job, court.
So they have, and this is a direct quote, "We hold that all evidence obtained by searches and seizures in violation of the Constitution is, by that same authority, inadmissible in a state court.
Hell yeah.
To hold otherwise is to grant the right, but in reality, to withhold its privilege and enjoyment." So they actually just full out overturned Wolf v. Colorado in this.
Wow.
As they should.
Wow, your wish is granted, man.
So,
feeling great about this.
Yeah, the court viewed this as a protection of the right to privacy and security of person and property. And basically the reasoning is that the court has a duty to protect citizens' constitutional rights and sort of watch out for government's attempts to violate them.
You leave DM and her nasty little drawings alone.
And so the court, since the court had previously held that states are bound by the Fourth Amendment right to privacy by way of the 14th Amendment's due process clause, they're saying that the state courts also need to exclude illegal evidence the same way that federal courts do. Otherwise, there's no real protection against illegal search and seizure. They also pointed out that, in prior cases, the court has very readily enforced against states the rights of free speech, the rights of a free press, the rights to notice and a fair public trial, the right to not be convicted by use of a coerced confession. So basically, they were like, well, we've already ruled against the states and told them that they have to respect these rights. So, like, it's really not that much difference in this situation. And then they said that the consistency between state and federal rules will basically allow for cooperation and investigation and prosecution of crimes, quote, if only by recognition of their now mutual obligation to respect the same fundamental criteria in their approaches. And then regarding the whole issue of, what happened, the person accused, they go free. They quoted a prior case in saying, however much in a particular case insistence upon such rules may appear as a technicality that inures to the benefit of a guilty person, the history of the criminal law proves that tolerance of shortcut methods in law enforcement impairs its enduring effectiveness. So basically, some guilty people will go free, but on the whole, it's protecting judicial integrity and constitutional restraints.
If you keep breaking into ladies' houses, reaching in their blouses and stealing their dirty drawings, no one's going to believe in the dang legal system anymore, please. You got to do your jobs right.
Basically. Yeah.
Yeah. It's a good way to ruin credibility.
Yeah, exactly. So the Supreme Court of Ohio judgment was reversed, and the case was sent back so that Ohio could do it again, but right this time.
Second chances for Ohio.
Mulligan cannon. That's new.
Ooh.
I didn't know that was possible. So wait, we can just be like, you guys got to true this. You guys got to do it again. You screwed up the first time.
You have to do it again
to a lower court.
These parameters that we have set.
Yeah. To a lower court, we can just be like, you guys.
Yeah, you gotta do
amateurs.
it again, but under these rules. These are the rules. Follow them.
That's why you jokers aren't on the Supreme Court. You got to follow these rules. Okay, that's good. That's good to know the full extent of our powers and the fact that nobody can truly stop us from doing whatever we want. That's also really important to know.
It's the powdered wigs,
It's the powdered wig. It's really, I can't take it off.
Sinking in.
I can't take it
Really
off.
sinking in.
So, okay, we learned a lot today. We learned that we can rule entire state laws unconstitutional. That's incredible. As long as it is, assumedly unconstitutional. That's probably important to mention. And the shenanigans clause, that's like critical. Like, you screw up 3 times, you're out, cops. Yeah, that's
we're not messing around.
We're not messing around. We're serious about this jurisprudence thing.
That's some excellent jurisprudence.
Thank you, my friend.
I say so myself.
Shenanigans will not be tolerated.
At least more than 2 times.
Right.
Before I get into some of the dissents on this, because it was not unanimous, my favorite quote from the majority opinion, this is a bit of a long one, but I think it really sort of gets to the heart of the matter of what we've been talking about over these past 3 cases, is, quote, "Moreover, our holding that the exclusionary rule is an essential part of both the 4th and 14th Amendments is not only the logical dictate of prior cases, but it also makes very good sense. There is no war between the Constitution and common sense. Presently, a federal prosecutor may make no use of evidence illegally seized, but a state's attorney across the street may, although he supposedly is operating under the enforceable prohibitions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold."
That's what I've been saying.
Ooh, that's an interesting
Common sense.
Angle. Mm-hmm. By upholding the state law, you are abrogating your responsibility to the national Constitution. I didn't realize that was an angle we could play. Thank you, dissenters.
Oh no, that was from the majority opinion.
Excuse me. Yes, majority. Excuse me, majority. Yes, I forgot we were on the right side of history this time. Yes,
right. That's what I was kind of trying to go at, because like when I was saying, the law is unconstitutional, it's like Ohio is enforcing a law on a person that is depriving them of their liberty, right? Because of the conviction. So it's like, why, but it's interesting to like actually view it from that angle where we're comparing.
Mm-hmm. Well said.
Was it
so wise?
Well, could have been worse.
Definitely could have been worse.
Yeah.
Let's see. For the dissension, so this is Justices Harlan, Frankfurter, and Whitaker. It should be noted, at least Frankfurter was on the court when Wolf was decided. I wouldn't be surprised if maybe some of these other words, but Frankfurter actually wrote the Wolf majority opinion.
Figures.
This guy. All right.
They were very displeased that the majority opinion was even about Wolf, because the
Of
case that
course.
came before them was actually about the constitutionality of the obscene materials law in Ohio. We did sort of skirt that a little bit in our reading of the facts of the case, because we were trying to keep things a little bit narrow for you all,
Probably
to just
smart.
sort of stay sort of in the lane of this little series here.
We need guardrails. Yeah,
And
you're right.
well, to be fair, you all and props especially to Chris, who was the first to sort of look at it and be like, well, hold on, wait a minute, but before we talk about Wolf, like, this law is pretty bad.
This
And
might be the backbone of this whole operation.
also having
It's
like
not
looked
very
over
much.
the transcripts of the oral arguments and also listened to portions of them, it seemed to me that the court thought it was kind of a bullshit law because there was a lot of discussion, like a lot.
I feel like I had the right spirit when I asked just how dirty was the drawing.
Yeah, you were getting there.
Yeah,
Did
there
it
were,
actually rise to the standard of obscenity as I hold it, which is considerably higher than average person, I have to assume?
there were some questions about, because there was a lot of disagreement about, oh, it was in the dresser, no, it was in the trunk, it was in a room, it was in the basement. And then the court like asked a lot of clarifying questions, and then once it was established that it's just having it just in your possession kind of broadly, like in the house somewhere.
Your Honor, I swear on my life, this
counts.
house was overflowing with smut.
Then they were like, well, it doesn't matter specifically where the police found it, but like there are a
It was
lot of
everywhere.
questions about like, okay, so if I have it on my shelf, is that illegal even if I'm a hoarder and I don't show it to anybody? And the prosecutor was like, yes. And then he's like, okay, well then what if you had I'm not going to give the precise title, but what if it was at the library? I don't want everybody running off to the library, but what if it was at like a university library? Is that illegal? And who specifically gets in trouble? There was a lot of like very targeted focus questions to the state of Ohio about this law, with sort of this undertone of like, this is kind of bullshit.
It does seem valid that if you're going to be like, some drawings are dirty and therefore illegal, you're inviting a slippery slope of inquiry into, just how dirty does it have to be really before we go and throw this lady in jail.
Yeah, who gets to say it's obscene? And they also talked a lot about this idea of like the Ohio State prosecutor argued that according to the law, there's just the fact that she had it, that it was within her property, means she was in possession of it, and it's the possession that's illegal. And the justices, including Frankfurter, I think he was one of the hardest chargers, who was sort of going through the whole like, so like somebody comes over my house and just like puts something in a drawer, and now I'm breaking the law.
And that's also part of why when it came out that the book was like missing, the first question was, oh, well, was the clerk indicted?
Hmm.
Yeah.
Ooh.
I mean, there was a lot of laughter. I mean, it was a joke, but like there was a lot of like there was a lot of laughter during the arguments, I will
We
say.
will find the men who tore these dirty drawings out of this hardcover. We will chase them to the ends of the earth and prosecute them in Ohio state courts.
Yeah.
For
Get 'em.
So for Harlan, Frankfurter, and Whitaker, they went into this thinking like, we're talking about a First Amendment case of like freedom of expression, and you can possess whatever you want to possess, within reason. But I think there was also a lot of questions of like, the court has ruled before that a state has the ability at some level to police things like obscenities or whatever, anything that could be bad for proper societal cohesion and that kind of stuff. But a lot of their dissent basically is just, wait, what is the majority even talking about? Why are we talking about Wolf? This was an obscenity law case, and then an ACLU lawyer showed up and had like a one thing one line where he was like, "Oh, by the way, I think you guys should overturn Wolf while you're here," and then that was it. That was what the case ended up being, and so they're trying to do two things in their dissent, where they're this grievance of like, what? Wait a minute. Why are we talking about Wolf? That's not the issue at hand. It's this Ohio law that's the problem, and then attacking the actual decision on Wolf, the upsetting of precedent. They say, to all intents and purposes, the court's present action amounts to a summary reversal of Wolf without argument. Our concern here, as it was in Wolf, is not with the desirability of that rule, but only with the question whether the states are constitutionally free to follow it or not, as they may themselves determine. And the relevance of the disparity of views among the states on this point lies simply in the fact that the judgment involved is a debatable one. So they say the question remains, as it always has been, one of state power, not one of passing judgment on the wisdom of one state course or another. In my view, this court should continue to forbear from fettering the states with any adamant rule which may embarrass them in coping with their own peculiar problems in criminal law enforcement. So the dissent is very much going for the Wolf was right because this is the states get to decide issue, and you took a case that was not about Wolf and you decided to make it a case about Wolf, and respectfully go to hell.
That's a lot of words to say that states are
Yep.
allowed to be as garbage as they want to be.
And
Yeah.
to be fair, like DM's lawyer didn't even like reference Wolf in his like written materials. Like he was asked about it during oral arguments, and he tried
knew it
to
just
like
rile them up.
he was just like, "Oh, I didn't mention Wolf," and then Frankfurter was like, "Yeah, but Wolf though, right?" And he was like, "Well, I mean, sure, but
See,
also
you know your
I
jurisprudence.
guess.
but also First Amendment and also cruel and unusual punishment." And then the ACLU lawyer was like, yeah, overturn Wolf and overturn this other thing and also do this other thing, to the point that one of the justices was like, "You're asking a lot of us today."
He was all like, objection. And the judges were all like, no way. And he was all like, way. And everybody clapped in the galley.
Apparently.
So to take a step back, put the case in context, right? So, thing I think about a lot when I'm sort of reading, because Nikki and I have to read a lot of Supreme Court related things to prep for this and to pick which cases are interesting to do. And we're not lawyers, so
And like also try to
we're-
understand all the stuff.
yeah. So, so we got to go through a lot of things to decide, like, well, what cases are we going to choose? And this case was originally episode 2. And when we were researching it and we were talking to each other, we realized that we couldn't really talk about this case. And the reason we want to talk about this case is because when you think about it nowadays, watch like any cop TV program, right? And there's always going to be the sort of like loose cannon cop who wants to get in there and do something, and then the calmer cop who's like, no, we got to get a search warrant, or they're not going to let it be evidence. Like, we live in a society where like that has been the rule for 50 some odd years now.
At least as long as Law and Order's been on TV, yeah.
Right.
At least.
Which feels like about that long. But so the reason we want to do this case is because I think we get sort of complacent when you grow up with a system or a rule like this and it hasn't changed in your lifetime. You kind of think that like, but it's always been that way. And the reality is like, no, it wasn't. And we want to talk about the case that made it so. But as we got into it, we were like, well, we have to introduce Wolf, and we got in, and that case was complicated. And so we're like, well, let's just do Wolf. So then we started researching Wolf, and we were like, well, Wolf is a response to or a clarification of the Weeks v. United States case. So what started out as one episode became this sort of 3-part series. This Groundhog's Day of illegal search and seizure that we've put you through.
What a trilogy, folks.
Because the progression for me is the so what and the changing of norms over time for 2 reasons. Number one, I just personally find it to be very interesting. Especially, I think I said it in the Weeks episode where it was like, okay, 1911, the federal courts finally decide, you know what, if the police screw up in gathering evidence, it's not allowed in federal court, which means from 1790 whatever to 1911, that wasn't the rule. And then so we got one new right that we didn't have before, but only in federal court. And then Wolf comes along, and you think, oh, okay, finally we're going to get a chance to do it on the state level. And they say, nah, it's cool. and to be fair, the arguments swayed you guys, 2/3 of you, just like it did the actual court. Then we come back with Mapp v. Ohio, and it's basically the same case, but what's happened is there's been, was it 15 years or so? It was like 1940 something to 1961.
That
So
sounds
there's
about
been
right.
10 to 15 years, new justices on the court, a society that maybe has gotten a little less happy about the way the police have been operating.
Yeah, we can't discount the latest scientific breakthroughs in the understandings of the nature of shenanigans as well.
Sure, yes.
And then also there were other cases, right, that were brought before the same court. Like there kept being cases of like, oh, the police are doing this, this, and this.
Yes. Yeah. There's a really, really great law article that unfortunately, I don't have it on my notes for this episode. I mentioned it in a previous episode that just goes basically from the Weeks decision through just the Wolf decision and a little bit after, and just talks about like all the cases where all of the various courts, from state courts to federal courts to the Supreme Court, had to like keep making decisions on like exceptions or slightly different circumstances, and how that started to get more and more untenable, where it's like, well, in this situation, this, unless it's like that, but in this like flow chart of ideas that,
all right, boys, you can still break in and seize evidence unconstitutionally, but only on the full moon or Sundays.
Right. But only if you have,
an odd number of men in your
an
party.
odd number of people and a Catholic to oversee everything, right?
If anyone in your party is named Greg, you're done.
Right. So by the time we get to Mapp, it felt very much to me, I mentioned this to Nikki earlier, and I really want to talk to some legal scholar who can answer this question to me. So if you're a legal scholar out there and you want to answer this question, reach out. But I sometimes wonder, did the justices on the court who decided to hear this case know that it was an opportunity to Wolf, even though the question they were being asked was really more about, Ohio's,
I'm sure
law.
it was in the back of their mind, right?
I mean,
I'm sure it was.
Yeah, I would guess so. Just given just the three justices' reaction once we started going into the facts of the case, and just the like, oh, come on.
Yeah.
And we live in a society where a lot of what we thought was settled precedent is potentially going to be reevaluated, and that is a very scary thing. But at the same time, I guess any positive I can take away from this experience going through these cases is that things have been in flux for a very long time. And at least in this particular case, it certainly seems like things trended in the direction of providing us with more rights now than we had in 1910.
For some reason, I'm feeling hopeful.
Yeah.
Maybe.
Yeah, this was 65 years ago.
Yeah, thereabouts.
Progress is slow.
But the other thing too is who's on the court matters, and we need to pay attention, which is why you need to keep listening to podcasts like this one and stay informed.
Yeah, we realize how completely, thoroughly soul exhausting it is to be informed, but Someone's got to do it. It can't just be us because we're clearly not doing a great job.
Yeah.
You gotta have good jurisprudence, fellow
Yeah,
listeners.
that is the one thing I do know. Yes.
Indeed.
Keep your wigs powdered, people.
Keep
That's
them
what we say.
powdered.
Thank you for indulging us on this 3-part journey.
Oh, yeah.
I genuinely thought, I mean, we got a little bit of it when we started going through the facts of the case, but I genuinely thought that there would be a riot or a mass walkout. It's good
close.
to know you guys will take a lot from a lot of abuse.
Listen, it was really hard for me to stay seated when the facts of this case once again opened up with, and by the way, no warrant.
It just seems obvious.
Yeah, I've
Yeah.
been taking copious doses of medicinal ether to get through the arduous details of this case, as is my right as a Supreme Court justice. I really, guys, hope you guys bring more suitable bribes next time, though. The offerings have been
Aren't you
less than
sponsored?
sufficient.
You're the one that's sponsored, right?
We could
the powdered
find
wig guys?
the obscene materials, make it available to the court for review.
Oh God, let's do it.
We got to put something on the website. So let's do it.
Fair enough.
New contest.
Relitigated.com.
Everybody send your favorite representation of what you think the nasty business was DM was drawing under spare
Just
time.
gonna I have to read these. I'm going to shut that down. I will be the one reading the emails. Please, no emails with
Jarrett at relitigated.com. Please send your nastiest DM fan art.
I
Fan
can't
art.
I can't right now express to you what I would consider to be obscene, but I would know it when I saw it.
You're going to learn, son. You're going to learn.
Oh wait! Oh, random fact. This is from Wikipedia. So apparently, DM was involved with illegal gambling operations that were run by like organized crime in Cleveland.
She got away with it. She got away with it.
She was acquitted, but then like the second prosecution a year later, coincidentally, I guess, happened to occur after she refused to testify against the racketeer running the illegal gambling.
Gosh,
Wow.
she's
I
so
ain't
cool.
no snitch.
Yeah, good for DM. I think.
Too cool for school.
I think she eventually moved to New York and then down to the South.
As you do.
Yeah,
Oh.
I mean, get out of Ohio at least.
What a go-getter, man. She should start an illegal lottery.
Back to that again, too. Yeah.
I do think I am a little concerned that we may have incepted the idea of running an illegal gambling operation into Adam's head, and that we may want to huddle up after this is done and disabuse him of the idea that would be a good idea.
Adam,
Listen,
if you run illegal gambling operations, the police are just going to bust into your house without a warrant.
Yeah, that would be considered a major shenanigan, I would think.
I've been trained
on
to
your
know
behalf.
that's bad. Yeah. Listen, guys, the
Self-inflicted.
line between legality and illegality is simply about what kind of lobbying effort you can muster. So I'm just saying this is the first step on a long road.
I think this is a good place to wrap it up
That's a great
before
place,
we.
Commit another major shenanigan.
Yes,
Yeah.
exactly. Yes, before we abrogate our own shenanigan test.
We gotta land this plane somewhere.
I really hope we're going to get into a season of dog law next.
Well, that was Mapp versus Ohio, and that concludes a 3-part discussion of the Fourth Amendment and the ways in which police can and can't bust up in your house without a warrant. The real life conclusion is that police, need a warrant. The Sarah Court has established a major shenanigans test to establish whether evidence should be included or not. And have established some other doctrines as well, the porque no los dos, and And I feel like there's another one that I forgot. There's
Todos as well.
Oh, yes.
Porque no los todos.
Todos, yes. Everybody goes to jail.
Everyone is guilty.
And also no snitching, I think, seems to be...
It's a common theme.
yeah.
Snitches do get stitches, unfortunately.
So
yeah,
you've
this
heard
court
it.
thinks very, very poorly of snitches.
So that's been the ruling of the Sarah court.
So get in line, people.
And so with that, thank you very much. Thank you to our justices. And just checking, is anybody here a lawyer?
No.
Never have, and I probably
Absolutely
never
not.
will.
Yeah, no, absolutely not. Wonderful. Well, thank you, everybody, and have a good night. That's it for this episode. To recap, in this session, the justices declared the Ohio obscenity law is stupid and illegal, overturned the conviction of DM, and clarified the Wolf decision by adding the shenanigans test. Aside from the shenanigans test, their reversal of the conviction actually somewhat matches the real Supreme Court's ruling in that in a 6-3 decision, the court overturned Wolf v. Colorado. Before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Thanks for listening. Please like and subscribe, and catch us at relitigated.com. Until then, I'm Nikki, and this has been Relitigated. Bye.